Five, three, two, one, action. Hello, guys. This is Mentor Lawyer, and everything is safe here in Tallahassee. We just had a major storm. Schools got canceled, courts got closed, but everybody's fine. We're going to talk about the case of State of Florida versus Donna Adelson. Of course, it involves the 2014 murder of FSU law professor Dan Markel. There's big news in the case. There was supposed to be a case management conference today at 2:30 p.m., and that has been canceled because of the weather. However, a motion for substitution of counsel was filed, and an order has been entered allowing the substitution of counsel in the case. So Ms. Descalzo is no longer the defense attorney, and now there's two defense attorneys representing Donna Adelson. One of them you're very familiar with. That's Dan Rushbaum. He is going to be representing Donna as well as having previously represented Charles Adelson. That has some significance in this case, and it tells us something about the defense of Donna Adelson, and I'm going to touch upon that in a few minutes. Let me first tell you about the second attorney who has just been allowed to take over as co-defense counsel for Donna Adelson. That's Robert Alex Morris. So I'm going to tell you a little bit about him. I know him very well. He's a friend of mine. So, of course, I'm not going to go into personal details, but I'm going to give you a good background on Robert Alex Morris. I know him as Alex, but his full name is Robert Alex Morris. He's a criminal defense attorney who graduated law school with me back in 1998 from FSU College of Law. So, let me first tell you about him. And, of course, as you may have recalled a couple of days ago, I think I did a video where I discussed some records from the jail that showed that several lawyers went to visit Donna. That included Ronald Thomas and Jenna Von C., who are really good attorneys at the Office of Conflict Regional Counsel. Mr. Thomas, I've seen him in person, do an excellent job representing Jeterius Williams in the murder of Harold Smith case. So he would have been a good lawyer for Donna, but in the end, it looks like the other attorney who went to visit Donna, which is Robert Alex Morris, he got picked to be the co-counsel and to work with Dan Rushbaum in the case. So a little bit about Robert Alex Morris. I'm going to call him Alex again. So he and I went to law school together. He was a close friend of mine during law school. He developed a soccer team for the law school, and we played not only the intramurals at FSU, but we also played at a league or at fields that are up north in Tallahassee, close to where I live now and where I still play, on the 6 versus 6 league. And so we had a law school team, and it had actually another criminal defense attorney who's pretty well known, Ethan Way. He was our goalie, and I was the scoring machine, of course, and Alex Morris was the stalwart of the midfield. So after law school, Alex Morris pretty much stopped playing soccer, but he became a youth soccer coach, and he has been a youth soccer coach, well-loved, beloved soccer coach here in Tallahassee for over 26 years now. And he coaches teams to tournaments and does a sensational job. He's really well-liked and respected and well-known as a soccer coach and also as a criminal defense attorney. His career has been devoted exclusively to criminal defense, and he has an unusual path in the sense that he didn't go to work for the state attorney's office or to the public defender. He started his career under the wings of a well-known local criminal defense attorney who was in private practice, and basically that attorney took him under his wings, and then eventually he went on his own. And on his own, he practiced again exclusively pretty much criminal defense. I'm sure that he occasionally does a couple of other things, but his focus has always been criminal defense. He's done a really good job. I had one time somebody came to me needing a criminal defense attorney when I was not practicing criminal defense work, which is most of my career. I did not do any criminal defense work. And he was the attorney that I referred the person to because I knew that Alex was going to do a sensational job for that friend of ours. He was a soccer guy too. So Alex is extremely experienced. He's not only a trial level attorney, criminal defense attorney, but he also does post-conviction work. He does appellate work. So he's got the entire package. Dan Roshbaum doesn't do appeals. He actually, on the other hand, does appeals and does post-conviction motions, which I think is actually a very valuable skill for any trial lawyer like myself to have a significant appellate experience. I find it very valuable because as an appellate lawyer, I also know how to preserve issues for appeal. And so I think that that is a valuable tool to have, and he has it. Really good lawyer. Actually, at the end of this video, I'm going to show you Alex Morris in action. He is going to be doing the closing arguments in the case involving the 2017 murder of 32-year-old Hoyt Birge, which took place in Tallahassee. This was a situation where there was an ambush. It was a murder that happened in a drug house. It really happened between friends when friends thought that this guy, Hoyt Birge, was going to rob them. And then they had a girlfriend. So there was two pages. Paige Briggs is the guy, and then Paige Vow is the girl. They were boyfriend and girlfriend. They lived in that house. And so what they did is they thought that this guy, Hoyt Birge, was going to rob them. And so they set him up. Paige Vow, the girl, invited him to come at night, saying that she needed some pills and that she was going to be alone, or that the other guy, Paige Briggs, wasn't going to be there. So he said, cool, fine, I'm going to get you those pills. He found another guy, a soccer player, by the way, Peter Turney, who was able to get those pills, and they both went together to that house and went into that house. And what happened inside there was a horror, which culminated in the murder of Hoyt Birge. The other guy was a survivor, and he found his way out of this mess alive. And I met him afterwards, and we did a soccer video together as a catch-up of where he's now. He's doing much better. Peter Turney, good guy. So in any case, so what I'm going to do is I'm going to show you Mr. Robert Alex Morris, Alex, in action. He's going to be doing the closing arguments. And the trial was against Georgia Kappelman. There were 5 defendants, 5 defense attorneys, and 2 of them are I know from soccer. The other one I know from soccer is Zachary Ward, and he actually represented Patrick Berain in that trial. And so Paige Briggs is the one who's been defended by Robert Alex Morris, and so I'll show you just that closing argument. But this case, this video is about Donna, so let me talk to you a little more about Donna. What does the fact that Dan Roshbaum stays in the case and now takes over as defense counsel for Donna Adelson tell us? It tells us something very simple, because if there arises any kind of conflict of interest between Donna Adelson and her son, Charles Adelson, who has now been convicted of the murder of Dan Markel, then he couldn't represent both of them. He couldn't represent Charles Adelson and Donna. But at the conclusion of the sentencing hearing, or towards the conclusion of the sentencing hearing, you all heard what Charles Adelson had to say. And what he had to say was, I maintain my innocence. And so therefore, he's still claiming that he did not order the hit on Dan Markel, that he was extorted after the fact, right? And he had no involvement, and then he eventually told his mom about it, and then his mom helped with those checks to Katie McManua, and so on and so forth. That was the story that Charles Adelson tried to sell at the trial, through his attorney, Dan Roshbaum, but primarily through his own testimony. That's the story that he obviously must have given Dan Roshbaum, because that was the defense that they presented. So what that means is this: the fact that Donna Adelson is hiring Dan Roshbaum and Alex Morris, the fact that she hired Alex Morris indicates to us that they I guess, listened to what their son had to say, their analysis about this whole thing about Tallahassee and how Georgia Kappelman is a local and how being from Tallahassee may have been an advantage for her versus Dan Roshbaum. So they listened to that and decided, okay, well, we better have somebody local to help. And then the second issue is, well, they're going to still go with Dan Roshbaum, which means what? It has a meaning, has a very straight meaning in this case. It means that they're going to present the same defense. They're going to stick to the same story, and Donna is going to say, that was the truth. The jury got it wrong. My son was extorted, and I only learned about it a few weeks later when my son was doing all those checks for Katie. And the story is going to be the same, in essence. The same story for everything. So we will see how that's going to pan out. But there is a surprise in that, in the sense that there would be a potential defense for Donna, which would be the defense of, well, my son told me that he was extorted and I believed him, right? And that defense, in a sense, if she says something like that, she's not saying that he lied, but she's hinting at the fact that even if he lied, she believed him, but she wasn't involved. So it is a difficult place for Dan Roshbaum to navigate this whole issue of representing Donna now that he formerly represented Charles. But I think that so long as his client is well informed and she's aware of the potential conflict of interest, and if she's fully aware that there is no conflict, only so long as her story remains the same, that she doesn't want to change it in any way, doesn't want to point the fingers at Charles Adelson, because obviously I don't think that Dan Roshbaum can present testimony at trial that would implicate her former client, his former client. At the same time, there is also the possibility that Dan Roshbaum will be an attorney on the case and will be actively participating in the case, but he's not going to be involved in the trial. And instead, Alex Morris may actually do the trial. So we'll see how that's going to pan out. And we will see whether any kind of conflict arises and then Roshbaum withdraws or stays on or whatever happens. But ultimately, you got to understand that the issue of conflict of interest is really resting solely on Dan Roshbaum's mind and his clients, right? So his client has to be aware of any potential conflict and waive it, and Dan Roshbaum has to be confident that there is no conflict, or that if there is a conflict, that he got a sufficient waiver for him not to be in trouble with the bar for representing Donna Adelson. And it is very often, it's quite common sometimes when you have people being sued in civil cases and sometimes prosecuted in criminal cases, if they're on the same side and they're not going to be pointing fingers at each other and there's no evidence, the state is not trying to prove that one was more involved than the other, and the trials are separate. So there may be situations where it could be okay to do that, to represent more than one defendant. But it's very it's something that I think all of us lawyers take a lot of pains to ensure that we avoid problems. And so the safest route for Dan Roshbaum would have been to just reject the case and just say, well, I represented your son, so now you need somebody else to represent you. But it's obvious that he and Donna, who was his former client, I think she was his first client in the case. And eventually then he switched to represent her son. So she was the first one to whom he had an allegiance, I guess, as a lawyer. But obviously there is a long-term relationship there. There's an issue of trust, and there is an issue of the fact that also he's 100% fully prepared to go, right? I mean, he just did the trial of Charles Adelson, so that is a huge advantage. He can help and guide and prepare her new attorney, Alex Morris, in getting ready for trial as well. And they can discuss strategy, what worked, what didn't work, et cetera, et cetera. So let's watch Mr. Alex Morris in action. Again, this is a trial that happened a few years ago with Judge Aumann as the judge presiding, with Georgia Kappelman as the prosecutor, and with several defense attorneys. And he was the defense attorney for Paige Briggs, the only one of the defendants who testified. I am planning to leave on a trip, but I'm staying on for as long as this video is playing. So if I decide that I have to go, because I'm looking at the weather, I may cut this short. But let me go ahead and share this with everybody. Thanks, everybody, for being here. Thank you for watching. Ladybug and I are going to continue to work hard to bring you awesome materials for you to watch on our channel. We, as always, enjoy and like all your support, and we thank you for being here. Where are the comments? Oh my gosh, here they are. Okay, hello everybody. I'm sorry that I had the comments, the chat off, so I didn't get to say hello to everybody, but let's cut to the chase. Hi everybody. I may just highlight your comments as we're watching the video, but I want to get started with the closing arguments by Alex Morris on behalf of Paige Briggs in the trial involving the murder of Hoyt Birge and the kidnapping of Mr.
That's just fine. All right.
Make sure the volume is as high as I can get it.
And Judge, thank you. Please the court. Counsel.
All right, here we go. If this volume is not good, I'm going to see if I had a higher volume version. This is the old ML before Ladybug entered the picture.
My first oral argument to an appellate court, I knew that the judge didn't appreciate what I was having to say because the center judge, there are three of them, just standing and sort of stretching or shaking off the cobwebs. That's.
I was talking over him, so I'm going to let him go ahead and talk. And I'm going to get out of here and just watch with you guys. So thanks, everybody. Let me go ahead and show you Alex Morris. Here we go. That's him.
My first oral argument to an appellate court, I knew that the judge didn't appreciate what I was having to say because the center judge, there are three of them, the center judge turned around and I was talking to the back of his chair. So with the caveat that the judge said, if you stand up and you turn around and I'm talking to your back, then I may have tuned you out. But your oath is to decide the facts in the case. You're going to make that decision divorced of any of your personal biases and things. We may not like all of the facts and the morality and a lot of the things that are swirling about in this case, but that's the oath and that's the discussion that we've had to this point. You know, Ms. Kappelman would really like to brush aside perspectives and how people perceive things. Let's not worry about any of that. That is to get you to jam and lump everybody together. We're going to hold them all accountable, all together. Let's get down to the evidence in the case. I'm going to confine my remarks to the way that I think that the state wants to structure and craft their case and bootstrap it in the direction that they want you to go. It's interesting, they're remarkably reliant upon the testimony of Paige Briggs in order to say that their case is bigger and better. I find that interesting, and we'll discuss that as we go through the evidence. I beg to differ with Ms. Kappelman's evaluation of whether or not she's able to pick her witnesses. That is not right. And the reason that it's not right is the government started picking right from the beginning. And let's talk about it, and let's address it, and let's confront it. Peter Tournay, I'm going to talk about him. And the reason is because he was in an interview room for 15 hours because the cops couldn't figure out whether he's a participant, a suspect, a victim, a witness. They can't figure it out. Probably for the same reason that we can't figure out what in the world was going on with him on the witness stand the other day. But they had to pick something, and they picked something before they had any evidence. They didn't know the full story. They didn't know that they were going to find DNA in a glove because he was busy loading a body up in the back of a vehicle. State's case is crafted on two witnesses. A bunch of I found out later, a bunch of hindsight, and a bunch of, yeah, I think that may have happened. Oh, and there's one thing that I'm going to completely agree with Ms. Kappelman on, and let's take it off of the table. Hoyt Birge did not need to die. I agree. I agree that Mr. Howard said it. I agree that Mr. Briggs said it. I agree that Stan West said it. I agree that Vicky Strickland said it. And I agree that Patrick Borain said it too, because he's crying and he's scared to death because that gun went off in his hand. She is 100% right, and everybody else in this room is 100% right. That man did not need to die. That's correct. So the decision to bring Tournay into the fold, it comes early on, really. You know, of course, this was Pete's first time smoking meth, and he did that just to stay alive, according to him. He drinking a little vodka, smokes a little bit more meth in the car. I don't know that we really know what Mr. Tournay's role was. Was it one where he was part and parcel of a robbery and was aware that it was going to happen? Then is it a circumstance that Mr. Tournay's colors have to change in the midst of what's unfolding because he can't be discovered to be an accomplice of a person, of people who are going to rob Mr. Briggs and Mr. Briggs's house? So he needs to portray himself as being innocent. To then have a body in the back of his mom's car, recognize that he's high out of his mind and he's drunk and he's driven up with a body in the back of his mom's own car. So his mom's asking him, and this isn't evidence, we don't know what his mom asked him exactly when he got home, but arguably, where's my car? Oh, Mom, it's got a dead body in it somewhere. It's not really the thing that I would suggest that you'd be excited to tell your mom. So don't you have to have a little story to explain all of that? We've got a circumstance, and I can't quite follow it. Mr. Tournay didn't have any blues. He does have blues. We're going to a drug deal. We're not going to a drug deal. Hoyt had the blues, and things were taken from me, but not any blues. I'm not really sure what exactly we were able to gather or gain there. What we do know, his observations, his perspectives, his ability to observe and recollect, it's kind of questionable. He enters the residence with Mr. Birge. He's confronted. He gets down on the ground. He's compliant. And the person who engages him is Paige Briggs. And he says that. He says other people are engaging Hoyt Birge. He describes only seconds going by and then bang. And then everything changes. He advised us that Mr. Briggs took the tape off of him, recognized who he was. He told you that. And it's at that point that the dynamic, I suppose, for him changes. As Mr. Shippey alluded to, at some point, from the time that the gun goes off to the point that he gets home, Mr. Tournay is not terribly precise about what's going on or what's happening. And what I mean by that are what his movements are inside Mr. Briggs's house, who he's with, what he's doing. The reason I mention it is there is some testimony that he goes outside on his own. There is some testimony that he goes out with Ms. Val. Mr. Tournay can't get away from Ms. Val. I don't know, he's talking about guns and people behind dumpsters or snipers on the roof or some nonsense. But that's, you piece together, you rely on your recollection of what it is that he's doing, who he's with, and how he's behaving. We turn to Jesse Fox. He says some things that match, and maybe they're of some importance in terms of helping us figure things out, but his story becomes so perfect, it becomes imperfect. And I want to discuss that because there are reasons for that. Mr. Fox has a massive amount of pressure on him. And that pressure is because, as you learned, he's an accessory after the fact in the homicide, and he's a cooperating witness. It would do Mr. Fox no good to get on the witness stand and say, yep, I was there to buy meth. Yep, I grabbed a gun and I was handling rear security, and I didn't go inside until after I heard bang, and I went in, and then I see that Hoyt Birge is deceased on the floor, and I don't really know how it all happened inside. And then I left, and then I came back, and then I helped get rid of guns and stuff. I don't think that that's going to buy him a benefit. I think that was the word that he used, was benefit. So Mr. Fox's testimony is kind of interesting, but he provides facts that are conveniently interspersed throughout the entirety of the case, and I want to identify some of those for you. He distances himself from everything bad. I want you to think about that and think about the testimony. Everything bad he pushes away from. I didn't have a gun. I didn't shoot him. I didn't see who shot him. I didn't want to keep or sell the guns. It was because somebody's mom's in the driveway. They just were foisted upon me. He's stolen drugs and money, but he's going to go back to the place that he stole drugs and money from a person who's threatened him on the phone, as well as his 6-year-old child. It's not making a whole lot of sense to me. He's going to take a shower in a residence where you've got another person and his girlfriend, Paige Briggs, Paige Val. There are guns in the truck. Everybody's loaded to the hilt. And he's going to go take a shower and not have any concern about it. That's completely contradictory of where we were at mentally shortly before with Mr. Fox. He's the only person that talks about Mr. Briggs getting some sort of alert phone call from Mr. Birge or whatnot. There's not any other evidence that correlates with that, and I'll come back to that in a moment. He knows just enough about the cameras that are located inside the residence. Judge, I think I'll be all right for this one because it's going to be short. And he points to this as being the surveillance mechanism and everything. It's not. And so it's over here. He knows just enough about it to misidentify where it is. He's also not privy to the fact, he knows just enough about cameras, but he's also not privy to the fact that there's not one in the interior anymore. They're all in the exterior. He doesn't know that fact. And so he's not able to accurately testify to the circumstance. He's able to throw in little details for your consideration. I think that you also need to pay attention to, he managed to see an awful lot of stuff from that tool closet or tool shelter. And you go back to your recollection, I asked him a question about it, but somehow he's seeing a lot of things from inside there. He heard a knock on the door or something, and I think he said, yeah, it was a faint one. He's looking through blinds that are either open, they're partially open, I don't remember. He seems to observe a great deal of things. Here's what's really compelling, though. He tells you the location of where Tournay and Paige Briggs are. He tells you the location of where he sees Hoyt Birge and whomever is around Hoyt Birge doing whatever it is that they're doing. What he fails to realize is that the place that he describes, Judge, I am going to ask for you to dim the lights if you don't mind. Not quite that much.
You need to put the different mode on there. Need some more light, Mr. Morris?
I think we're okay.
Okay.
So And you're able to pass this around back there, and I think that you get the point, and I think that you got the point during his testimony. He identifies that he's standing way back here in the kitchen and that he never came any closer. But what he doesn't realize that he's telling you is that there's actually a hallway there, and there's a wall that's about 4 feet, and you can gauge the distance for yourself. And he was very specific in saying, I never went past here. And it's impossible, because around here is where this gentleman is with Peter Tournette. And I think what it confirms for us is exactly what I'm driving at. He didn't see anything that happened inside. He came back inside that house. Thank you, Judge. He came back inside that house after he heard the bang, and then he made his decisions, assumptions, that sort of thing from what he was picking up after the fact. And unfortunately, he keeps trying to jam facts in a backward direction, and they're just not possible. But you can decide for yourself. He's the only person that talks about it being this struggle that settles down. That the way that he describes it is that it's really this volatile thing, and all of a sudden he's of the belief that everything is okay and that they've resolved their problems. It's at this point that he's going to exit the residence. And then by the time that he gets outside, that's when he hears the bang. He re-enters the residence, and he's the only one actually that describes this very lengthy, well, I'll say very lengthy, describes this conversation that's going on between Patrick Borain and the decedent. I'd suggest to you that he probably got into the room and Mr. Birge either was expiring or had expired. And as I mentioned, you'll be able to be the judge. You don't have to take a note. Hopefully somebody does. If you look at exhibits number 36, 37, and 49. The state's placed great emphasis, and all I'm going to do is I'm going to point. Yep, I can get it. All I'm going to do is point to it and bring it to your attention. The state's made great emphasis about everything was dark. This was a clandestine, organized lure in. I'm going to tell you, and it's visible, porch lights on. Porch lights on. Rear porch light is on. So, and I'm certain that Ms. Kaplan will say, we don't know when it got turned on. It may have been turned on afterwards. That way everybody could see. Well, it's on. These are the photos that law enforcement took, and maybe everybody went hauling butt out of the residence in a panic and said, oh, Paige, make sure that you leave the porch light on. So that's really the state's case, if you think about it. That's it. We know that Hoyt Birge passed away as a result of a gunshot wound. We know that he had significant head injuries. We know that from the medical examiner. There's no question about that. We know that there are a bunch of hammers that are seized. We know that there are conflicting accounts of who's involved in what with Hoyt Birge and with what weapon. We've gone from ball peen hammers that are 3.5 inches to, I don't know, these other 10 that are of varying different sizes. We've had brass knuckles mentioned. So then the state rests, and there are 3. I'm going to come back to the remainder of the evidence, and I've got troublesome things in our arguments is that I've got to anticipate what the state's going to say and rebuttal to my argument. There are 3 things that I think that Ms. Kappelman is going to hit your cart to. One is principle. Mr. Shippey mentioned it, but I'm going to mention it a little bit different way. The law is not load everybody's wagon the same way and then the judge gets to figure it out. That is not the case. There are 8 race cars that decide that they're going to do a race around a racetrack for 1 minute. And in that race, car number 3 intentionally takes car number 4 out, and car number 1, it's to their benefit, and car number 5 just crashes. Everybody doesn't get saddled with all of the crashes and all of the wipeouts and the intentional conduct or unintentional conduct of other people. It doesn't work that way. And Mr. Shippey used the analogy of get you to that point. Everybody doesn't go across the finish line responsible for all of the wipeouts and the crashes. Some of them nefarious, some of them unintended, some of them intentional, but others don't know the reasons why they're intended. That's not what the principal theory is. For each element, for each offense, for each defendant, beyond and to the exclusion of a reasonable doubt, it must be proven that the person had the conscious intent that the other person committed the crime. The second thing that I think that the state will make mention of is reasonably foreseeable. The argument being, well, you've armed yourselves for this discussion or this confrontation. Wasn't it reasonably foreseeable that Mr. Briggs, you went over to engage Hoyt Birge, so it must be reasonably foreseeable that a hammer that no discussion has been had about, that there's some plan that another individual's decision-making about something completely different is going to happen. That's not reasonably foreseeable. You know, I suppose if you have a gun, there is the possibility of the gun going off. But I don't think that there was ever an intended purpose of that. That's all of the testimony that's before you. I don't think that given the scope of the plan, we're going to dummy him up and get his attention and know that you don't come around here and rob me. You don't threaten to rob me. The plan wasn't, let's make sure that we act in such a way that it would be reasonably foreseeable that a firearm would discharge. Also, Mr. Briggs can't be held responsible for whatever the reactions of other people are. And let's, true or not, let's take the example of this. If there are responses by individuals where they go to confront Mr. Birge, and Mr. Birge is reacting in a particular way to those people that heighten or escalate the need for restraint, response, defense, and Mr. Briggs is otherwise occupied and focused on a completely different individual, how then can he be responsible for the conscious intent, the decisions of the other person or persons? He can't be. He doesn't know that those decisions are being made. He can't adopt those perspectives. The third thing that I think is likely to come up is there is a phrase in the jury instructions that self-defense or justifiable use of deadly force is precluded with the phrase unless is otherwise engaged in criminal activity. There are 2 places that you'll see that. I'm going to ask you to read those jury instructions really, really carefully. And the reason that I say that if I'm a great thief of gumballs and I store all of the stolen gumballs at my house, it cannot possibly be the law that because I'm otherwise engaged in criminal activity, that I cannot defend myself against intruders who are coming to rob me. It can't be the law. So read the jury instruction in its context. I do want to talk about the counts. The instructions are brutally long and they're confusing as all get out. and make no mistake, neither the judge nor any of the lawyers in the room have made the decision to construct the instructions in the way that they are. They are given to us from on high. And we don't have that much of a say in the matter. There's no evidence of premeditation at all. And on the first-degree felony murder, there's not a kidnapping for many of the reasons that Mr. Shippey argues, but Mr. Birge comes into the residence. He's immediately down. There's an altercation. There's a fight. That is, none of that is kidnapping. The state's trying to push that agenda to turn it into kidnapping. Why is it not battery? Why is it not aggravated battery? Well, the reason it's not any of those things is because that's not a qualifying offense to get you to first-degree felony murder. And there's not a robbery of Mr. Birge. We know that nothing's taken from him. He's not threatened, give me your watch, give me your money, give me your drugs. None of that's happening. And the same, I believe, is applicable to Mr. Tournay as it relates to felony murder. Mr. Tournay, he's complying, he's down on the ground. I understand the tape issue. I have no idea why I don't have any idea why a lot of people did most of the stuff that's involved in this case. There's no question about that. Why somebody's wrapping tape around somebody's head that they can still see through a little bit doesn't make a whole lot of sense, but there are a whole lot of nonsensical things that occur in the case. But as soon as Mr. Briggs recognizes who it is, the tape's removed, and that's when we have Mr. Tournay hanging out on the couch and smoking and drinking and going outside. And so I'm having a hard time figuring out, and look at that second part of the instruction. The state gave you the first part of the instruction on kidnapping. Look at the second part, because you're going to get to the elements, and the state left out it can't be slight, merely incidental to the robbery or the aggravated battery. We know that there's not a robbery. Arguably, there's an aggravated battery because of the nature of the injuries, as well as the potential weapon used, and you'll find that in the instructions. But it can't be part and parcel of the same, is the point. And so look at those three instructions and see what you're able to discern from those. Second-degree murder. By all accounts, Patrick Borain accidentally discharged the weapon. The state now chooses it to be an intentional killing and argued to you in the alternative, I guess. His conduct may have been negligent. You're going to find the definitions, though, for second-degree murder. I mean, the state even defined, and I want you to think about this because the state defined it. A drive-by shooting where somebody is intentionally firing a gun at a residence, out of the window of a car, into a residence, and somebody is killed. That's second-degree murder. That's not first-degree murder. That's not premeditated murder, according to the state. That's second-degree murder. And the language on the mindset and what a person psychologically has to do, there is no evidence at all that Mr. Briggs adopted Mr. Borain having that type of mindset. It doesn't exist. So let's look at the intent element and what has to be going on in the brain. Obviously, there's an issue related to self-defense in the case. And in the event you were not to agree with self-defense or you were not to apply it, say, nah, they didn't do first, they didn't do second, state hadn't proven it, but we're not buying this whole self-defense thing. You're going to get to third-degree murder, and you're also going to get to manslaughter. Look at the instructions. It does pretty closely mirror, both of the instructions pretty closely mirror the conduct, but only if you make the decision that self-defense does not apply or is inapplicable. Essentially, the third-degree murder, in a nutshell, is that Mr. Briggs would have had the conscious intent that an aggravated battery, an aggravated assault, a false imprisonment, or a drug sale or purchase, and then a death resulted in the midst of that. Those would be the facts, generally speaking. I don't want to misstate the law. Manslaughter, on the other hand, is a circumstance where essentially everybody's behaving so negligently, and then a gun is discharged and a person is killed, and you're able to apply the facts as you believe them to be. On the kidnapping charge, I've already addressed it. There's no need to repeat it. There's not a kidnapping of Hoyt Birge, and there's not a kidnapping of Peter Tournay. And I want to go one step further on the Peter Tournay issue, and the reason for that is this. First of all, in pretty short order, Peter Tournay is wandering around doing whatever Peter Tournay is doing. And Mr. Briggs is hearing all of these crazy ideas about, well, let's do this and let's do that, and who's doing this and where are we going? And ultimately, Mr. Briggs, Paige Vowell, and Jesse Fox are gone. And Mr. Briggs is not in a vehicle with Peter Tournay, and he's not participating with anybody that's in that vehicle, and he has no earthly idea what's going on or being said. And I would suggest to you that if you even believe that anything like kidnapping applies to Mr. Tournay, Mr. Briggs is well out of the picture. The same really applies to the carjacking. And that's why I say this whole concept of the principle thing is, oh, no, it was the plan. And Ms. Kappelman used the word the plan and the conspiracy. So the plan and the conspiracy, when they all got in the huddle, was this is what we're going to do. When they come in, somebody gets some hammers, even though you don't have them. Somebody beat him senseless. Let's have a gun go off. And then afterwards, I got a great idea. Let's put the body in the car of Peter Tournay's mom, and then let's drive him home, and then let's take the car from there. That had to have been the plan at the inception. It's not a rolling thing. You've got to, the state's kind of got to figure out exactly how to prove their principal theory. Mr. Briggs was a witness in the case. You're able to evaluate it, and there's criteria in the jury instructions for you to be able to evaluate it. Did he seem honest and straightforward? What's his body demeanor? How is he answering the questions in a manner that's responsive? Is he evasive? Were there things that Ms. Kappelman was able to catch him in lies and impeach him and show that he's made different statements? I know that he didn't get the vocabulary word deduce right, but other than that, you can take the testimony for what it is. Let's talk about some important things that you otherwise would have been prohibited from knowing, that you weren't made privy to. You got to learn the lingo of the messages. It's not in my vernacular. Well, it is in my vernacular because this is my job in terms of what the contents of those messages are. I know what they mean, but it's not in common people speak. Most people don't know what a lick is. Most people don't know. I went and peeped it. And so we got to learn the context and the lingo from Mr. Briggs. It's clear Michael Cooper, Hoyt Birge, intended to rob Paige Briggs. I'm not going to go back through the messages. You can look at them. You can figure it all out for yourself. We also learned that Hoyt Birge had prior assaults, prior burglaries, prior weapons charges, prior instances of stealing drugs and offering to do harm. Essentially, you got to learn that he's a violent guy, and he's the kind of guy that follows through on the exact commentary that is contained in those messages. We also got a better understanding of Stan West and Vicky Strickland, and also Patrick Barain. And here's why that's important, is because this is not Mr. Briggs picking up the phone and calling his posse to come over in order to get everybody together and let's have a beat down and lure somebody in. They all live there. Vicky and Stan live there because of their personal circumstances and living arrangements. And Patrick Borain does also because he's in transition from one girlfriend to the other. We also learned that Mr. Howard is kind of an interloper. He was planning on coming over in the first place, and he comes into the picture because he had already planned to be there. He gains the information. We learned Paige Vowell is also a resident. And then the other interloper really is Jesse Fox. And if anything, I would tell you that he's probably the most outlying of the group. And the reason is because the only reason he got there is because he just kept pestering the hell out of Mr. Briggs in order to get drugs and get high. And he becomes aware of the circumstances and situation. So we also got clarity of the fact that there's really not a grand plan. It's as Mr. Briggs, or as best we can discern, it's as Mr. Briggs, because there's no evidence to the contrary. The state kind of shapes it as they want to teach him a message, dummy him up. Well, you know, I don't think that there is a plan. The plan is, let's make sure we're not getting robbed by this person who has threatened to rob me. And then we'll figure out whether or not he really means this. Let me tell you something that's interesting and important. You know how we've talked about, oh, there are these messages and Hoyt Birge was lured? There aren't any messages. They're not in evidence. We don't know what the messages said. The only testimony that you actually have is, in my view, Mr. Briggs's candid acknowledgement that those messages were sent theoretically because that seemed to be a way of controlling the potential threat and the potential surprise. Those messages don't exist. We don't know whether they say bring blues. We don't know whether they say, hey, why don't you come over? And so you learned that from Mr. Briggs, from us. And arguably, it makes us look worse, doesn't it? Because we acknowledge the fact that we're trying to control a circumstance. But I think that it's best you be fully informed. I don't think that there's any evidence that any blues really existed. There's not any evidence before you, and Mr. Briggs makes this pretty clear, and I think all the witnesses do. There's not any evidence of them going in the house. I mean, we got Peter Tournay, who's all back and forth and Twitter-pated about what it is that he's telling you, but there's never any evidence of blues being in anybody's pocket or inside the residence. We don't know whether or not they made it. The state very well could argue to you, disregard what Mr. Briggs's statements are because he's got skin in the game. There is no doubt he's got skin in the game. The man's life's on the line. Use the same tools that you utilize and that the judge has instructed you on to evaluate other witnesses to evaluate his. All right? There are rules that create a fair playing field for everybody. We learned that Mr. Briggs did not want Hoyt Birge to die. We learned that his death was tragic. And we also learned, he said, yeah, I absolutely am accountable. He said it. Contrary to what the state says, we also learned that, I believe, rely on your recollection, that Vicky goes to his aide and is talking about we need to call 911. I believe that there's information about maybe Stan or somebody else. Mr. Briggs said that he did, and they arrive at the collective conclusion that the guy is not dead. And Ms. Kappelman, through her questioning, may be 100% right. He may not have been clinically dead. But what is important is for you to recognize and understand what their perceptions and conclusions were. At that point, there is all kinds of we're going to cut up the body. We're going to get Tupperware containers. We're going to go bury the body. What do we do with Pete? And ultimately, all of these bad ideas that everybody's got, none of them were followed through on. And it suggests that none of them were smart ideas and that none of these people are killers with premeditation and felonious intent, and it was an accident. So rather than eliminating and killing Peter Tournay, he got dropped off at his mom's house. Rather than cutting up and burying a body, it was left in a trunk and people went to sleep. All of it, everything after they perceived Mr. Birge to have expired was sheer panic. We also learned from Mr. Briggs the people that he was seeking out the hardest and the fastest were his parents. Because I knew I was in over my head. Somebody has been killed in my house. I had to get to them and tell them what happened and get their advice. He went to their home, they were not home. He went to their beach house, they were not there. And there was a short period of time that lapsed before law enforcement arrested him. And so he never was able to gather the benefit of their advice in that short period of time. So the state kind of quipped in opening statements because of my stupid peanut butter and jelly thing, Mr. Hobbs's Big Mac thing, that they were going to deliver to you the full value meal and it's going to have extra fries and all kinds of whistles and bells on the side. I'm going to suggest to you that the standard of beyond and to the exclusion of a reasonable doubt as it relates to first degree murder, premeditated felony murder, the first degree, second degree, each of the murder counts have not been proven beyond a reasonable doubt because of the self-defense issue. Also, though, if for some reason you were to reject it, then I think that the only way to look at the evidence is going to be through the lens of third or manslaughter. And I completely disagree on the whole kidnapping thing as well as the carjacking thing. We all agreed to hold the state to that burden. I'm going to make a suggestion to you that upon reflection and evaluation of the evidence, that may be a better way of defining what beyond a reasonable doubt is that you'd be willing to rely upon the testimony and the credibility of persons such as Peter Tournay and Jesse Fox in these circumstances. In the most important of your everyday decisions, and rely upon it without hesitancy to make your own decision. And I would suggest that that's beyond a reasonable doubt. And I don't think we're there. I'm the last voice that you are going to hear from Paige Briggs. He does need a voice in the jury room to discuss and debate intelligently the law and the facts. It's incumbent upon you. I don't have a rebuttal. The government gets the last word. We talked about it with some of you in jury selection. The process was so drawn out. Some of you weren't participants, some of you were. It's an awesome responsibility. It's a solemn responsibility. You've seen pictures of the scene, heard testimony, you've listened to different people's perceptions, their interpretations, their frights, their fears, their reactions. You're the ones who draw the final inference. As everybody else has mentioned, you're much appreciated. You have been diligent jurors. You were very engaging during the selection process. You've been engaging during the trial. You've worked hard to this point. There's hard work still to do. And I look forward to you rendering a just and fair verdict. Thank you.
Thank you, Mr. Morris. Everybody doing okay? All right, Mr. Bajowski?
Yes, sir, Your Honor. Ladies and gentlemen, let me, I hope I can be a little shorter.
Because I know you have already heard all of the facts from the testimony, and you've heard some of the highlights. A few things that I want to be sure you understand is what we talked about in the very beginning, and that was the presumption of innocence. Mr. West has testified. He got up and said, "I'm not guilty." And with that, you are supposed to presume him to be not guilty. Okay? Presume him to be innocent. So for him to have to get up and testify again, on top of what Mr. Briggs said, or on top of what anybody else says, to just keep adding more and more of the same testimony, that is pretty much clear, would be unnecessary. And he exercised his right to remain silent. And I want you to remember when you go through the jury instructions, okay, to notice again, this is his constitutional right. It's 300 or 400 years old in the English judicial system. And you are not allowed to assume in any way that by not testifying that there is some question about whether he should have been considered innocent at the beginning of this case. He's innocent. Now the question is whether the prosecutor has, by beyond a reasonable doubt, presented enough evidence to convict Mr. West or any of the others of a crime. And I want to say first that just as Ms. Kappelman says the law applies to everyone the same law that would apply to Mr. David Howard or to Mr.
All right, everybody. If anybody wants to watch the full trial in the murder of Hoyt Birge, then let me know in the comments. And if we get a lot of comments that you guys want to watch the full trial again, I think it's mostly private right now, then eventually I'll get Ladybug to work on that and make the trial public again. So again, to summarize, Dan Roshbaum and Alex Morris will be representing Donna Adelson in the case. I spoke my initial thoughts about it in the very beginning of this video. I showed you now Mr. Alex Morris in action in the very difficult case of the murder of Hoyt Birge, where he was representing the guy who set up the whole he was the owner of the house. He was the one who got his girlfriend to invite the victim to his house, and he set up the ambush. He was recruiting people to attack Hoyt Birge when he arrived. They were going to surprise him, and they did surprise him. They came from the back rooms armed with weapons, and eventually this whole thing ended in the murder of Hoyt Birge. So it was a very difficult case for sure. And all the defense attorneys got a good result in the sense that none of the defendants were convicted of the highest charges with which they were charged. One of the defendants, Vicky Strickland, got a not guilty. All the other ones got, I believe, a conviction for third-degree murder and were sentenced pretty much to the maximum that allowed. So they all were serving long sentences. They were all young men, except Vicky was a young woman. She was in her mid-30s, I believe, and she passed away from an overdose a few months after she got the acquittal. Anyway, thanks everybody for watching. I gotta get ready for my trip. I got a lot of work this week in Orlando, legal work on my cases, and Miss Ladybug is gonna be taking care of Deep Dive True Crime here in Tallahassee. So last week, in the last couple of weeks, she was gone and I was here on my own, and now she's gonna be taking the reins of the channel for the next few days while I work on my legal stuff, on my cases. I do gotta work on my cases. That's how I make a living. So anyway, thanks everybody for watching. Thank you for being here. Thank you for liking and commenting. And be sure to compliment Miss Ladybug with her editing skills, because she's getting better and better. And I want her to hear from you guys how you appreciate the better work that she's doing every day. So her next video is going to be even better than the last one. And if you haven't watched it yet, you should watch the timeline video that she and I worked on together. Well, she did the video. We both worked on the timeline together, but she did the video, and she did an amazing job on that video. So you guys better watch it, like it, share it, etc., etc. All right, guys. Thanks for watching. Do you want to wave? Bye-bye. She's still camera shy, back from vacation. I think you saw her hand waving there, but she's back, and she's back in action. Thanks, everybody. Until next time, mentor, lawyer, and Ladybug hiding in the corner. Bye-bye.